Welcome to the Probate Nation. My name is Richard Ruddy. Probate is a process to transfer the title of probate assets to the beneficiaries of a deceased person. To do so, you have undertaken to get yourself duly qualified as personal representative to probate those assets located in the state where the decedent lived. But what about that beach house or second home in another state? Does your probate authority automatically extend to those probate assets? Do you have the authority to list and sell that real estate? And the answer is no. However, that authority can be acquired through a process called Ancillary Probate Administration in the state where the assets are located. But be advised that the process to obtain that authority varies with each state. Tonight we will focus on ancillary probate in Georgia, from how to initiate an ancillary probate, steps to be taken during that probate, and how to wrap it all up. And to do so, we will have with us tonight a Georgia attorney who will share his expertise and guidance on this topic. Our guest is the founding partner of the Curtin Law Firm, a boutique estate planning and administration law firm located in Atlanta, Georgia. In addition, he serves as a court-appointed attorney for proposed wards in adult guardianship and conservatorship matters, and as a guardian ad litem in contested estate administrations and guardianships. He is a past chair of the estate planning and probate section of the Atlanta Bar Association, and he has been a presenter to attorneys in Georgia bar CLEs and to financial advisor groups in the areas of estate planning and probate administration. Please welcome Atlanta attorney Tim Curtin. Hi, Tim. Welcome back.
Hi, Richard. Thanks for having me.
You bet. I appreciate taking the time. Well, you know, it's funny. We have seen more and more need for ancillary probate administration as we've handled estates here in Virginia. So let's talk about what is ancillary probate in general.
In general, ancillary probate is when probate needs to be opened in another state, not the primary state where the decedent was residing when he or she passed, but in another state, usually to give the executor the ability to transfer real estate in that other state, to your point, a vacation home most typically.
Okay. Now, who needs to undertake the ancillary probate in Georgia?
It is typically the executor who is appointed in what we call the domiciliary state, the state where the decedent died, but it doesn't have to be.
Okay. And what assets typically need to be probated in Georgia by a non-resident decedent estate? Which I ask that question, but I typically see that as being a lot of times a second home or a beach house. But what do you normally see?
It's a second home, a beach house. We have farms in southern Georgia, and many times I will see inherited property for those types of farms.
Okay, so let's talk about what court actually oversees Georgia probates then.
The probate courts in Georgia have exclusive jurisdiction over the probate of wills and even the administration of estates for people who died without having a will.
Now, you've told me previously there are quite a number of, there's a probate court in every county in Georgia. Is that correct?
That is correct. There are 159 counties in Georgia and 159 probate courts. And although they are generally on the same page, every court has its own method of doing things. So it's very important that you're familiar with that particular probate court when you're trying to file paperwork or get something done.
So it bodes well to try to get someone local who maybe understands how that court works if you have to do some work there. What is filed with the probate court to initiate an ancillary probate?
Georgia probate courts are generally run by what we call standardized forms, and the court promulgates these standardized forms and they encourage you and sometimes even require you to use those. Interestingly enough, there is not a standard form for a ancillary administration. So you have to modify one of the standard forms and point out to the court that there already has been probate initiated in Virginia, for example. So we don't have an original will to produce to you because it's already been filed in Virginia. But we need to have an executor appointed in Georgia because, to your point, there's real property or some other type of property that needs to be conveyed in Georgia.
And in order to do that, do we need to produce anything special from the domiciliary estate that where the person had died?
Yes, the courts will want to see a certified copy frequently of the entire probate file from the domiciliary court.
Okay, yeah, that's what we refer to that here in Virginia as triple seal copy of everything that's in the probate file. And so what can be done with the real estate once the ancillary probate has been initiated?
When the probate has been initiated and when the court has approved the person to become the ancillary administrator, they're given paperwork.
Okay.
And they are called letters of administration. And I analogize that to a financial power of attorney for an estate. And that gives the administrator the legal authority to really transact whatever business they need to transact in Georgia, but specifically to convey real property, because in order to convey real property in Georgia, you need to file a deed in the county deed records, and the deed would really essentially be invalid if you didn't have the letters testamentary filed along with them, so the world knows that the person who filed the deed had the authority to file it.
Sure, that makes sense. That makes sense. So let's talk about the duties of the personal representative who's appointed as an ancillary administrator. What are those duties?
Generally speaking, the main duties are still lie with the domiciliary executor or administrator. And in most cases, the ancillary administrator is the same person as the domiciliary administrator. So it's really, it's just a different hat that person is wearing to give them authority to do something in a specific state, in this case, Georgia.
Okay. Now we've previously discussed, in a normal Georgia probate that there's different types of filings that would be made by way of inventories and accountings and so on. Now, does an ancillary administrator have to make any of those types of filings with the court?
Typically, we would have those waived. It's like any other. It would just be like the main process that hopefully the will waives those requirements, or the beneficiaries would waive those requirements.
And those beneficiaries could be located anywhere. They don't have to be in Georgia, so they could waive it no matter where they lived. Well, that's good to know. That's probably one of the very interesting processes in Georgia that makes things a lot simpler to kind of get that estate moved along, rather than going through the details of formal accountings. Well, let's talk about the process to wrap up an ancillary probate. How is it closed?
There is a standard form called a petition for discharge, and in that petition, the ancillary administrator states that the duties have been carried out. It really would need to be filed essentially contemporaneously with the discharge paperwork in the domiciliary jurisdiction.
Okay. Is there any sort of notice that has to go out to everybody when you do that, though? I want to make sure I get that straight. When you file your petition for discharge.
Yes, all beneficiaries need to consent before an administrator can be discharged, can receive a discharge.
Okay. Now, again, ancillary administration, again, what's the normal time period for that to be taken care of from beginning to end? Well,
usually it's much quicker than the main administration, because it is usually for just a discrete act. So it would be, we have our vacation home, the decedent had the vacation home in Georgia. We need to get them appointed so they can have authority to convey the property via a sale, or to transfer the property to the beneficiaries that were named in the will.
Okay. What's what's the typical cost involved to initiate an ancillary probate?
In terms of the filing fees, most initiations of filing fees are around $300.
Okay.
The paperwork can be filed without the assistance of an attorney. I hate to estimate any type of fees on my behalf or anybody else's without knowing the full nature of the work that would be involved.
Of course, of course. Well, in this ancillary administration discussion today, a lot of the focus has been on real estate. Okay, so in the case of the Georgia real estate that someone owned, whether it's a beach house or family farm or something like that, what could have been done in advance of the decedent dying to avoid having to go through a Georgia ancillary probate?
Two main things, in my opinion. The first is planning through what we call a will substitute, and that the most common vehicle goes by a lot of different names: revocable trust, revocable living trust, a living trust. When I create a trust, a living trust for my clients, I analogize it that you are placing assets in a bucket, and that bucket has a list of instructions on the side of it saying what happens to those assets if I become incapacitated or if I die. And the assets in that bucket are not part of the probate process. They pass outside of the probate process. So if your client Richard in Virginia had passed away and had a revocable trust, and they had already transferred their Georgia property into the revocable trust, then they wouldn't need to open ancillary administration in Georgia. Another method is to place the property in what we call limited liability companies, and that would be an entity that would hold the real estate, and when the decedent passed away, the decedent would be distributing the LLC interest, the limited liability company interest, and not be conveying real estate. So we would not need to open an ancillary administration in that case either.
Okay. Well, those are two good suggestions. Now, we talked about, having, out-of-state decedent owning property in Georgia that we need to probate. But what happens if, before anybody passes away, they decide that they want to go ahead and move down to Georgia and take up residence in that beach house or the family farm or whatever it might be, and so now they become Georgia residents? Okay, so again, now we're not talking about necessarily ancillary administration in Georgia. We might be talking about it in another state, okay, because of stuff they left behind. But what are some of the things that those folks that are moving to Georgia, who have estate documents in place, what are some of the things that you would suggest people need to take a look at as they come to Georgia and take up residence there?
The first step is to see what documents the client already has. In Georgia, we are still traditionally what I call a will-based estate planning state, meaning that because the probate process is relatively simple, most people still elect to do their planning through the will as opposed to the revocable trust. Now that's changing a little bit, but as the courts get busier and busier, but that's still the default. So if a client comes in with a revocable trust, my advice to them is almost always keep the trust. It is a better estate planning vehicle. We have other documents that are particular to Georgia. Every state has them really, but we have a Georgia Advanced Directive for Healthcare, and that document allows you to appoint somebody to make medical decisions for you if you can't make them for yourself, have access to your medical records, and also outlines certain end-of-life decisions that you'll make on your own behalf, instructions to your agent and to your physicians. If every state that I'm aware of has a healthcare directive or a healthcare power of attorney, but just as a practical matter, the Georgia hospitals are more comfortable looking at a Georgia Advanced Directive for Healthcare than a Virginia Healthcare Power of Attorney or or whichever document it is that Virginia used.
Okay, that's good to know. Now, and I think I think also we talked a little bit about the fact that if you have a will that has a self-proving affidavit, there are different things that are very specific about what Georgia probate courts will accept, okay? And a lot of times those affidavits don't say exactly what Georgia may require. So I think you mentioned this before, maybe you want to touch upon that?
Yeah, that's a great point to bring up, and I can't tell you how many times I see this, because I think it is a quirk that only Georgia has. To refresh everyone's memory, a self-proving affidavit is attached to the will, so you don't have to track down witnesses when it becomes time to enter the will into probate. One of the requirements of the Georgia self-proving affidavit is that all of the witnesses are over 14 years of age. And that has to be stated in the self-proving affidavit. We can't submit a copy of a driver's license, for example, or something like that. If it's not stated in the self-proving affidavit, it's no longer it's not valid as a Georgia self-proving affidavit, and so we need to track down the witnesses. We have a lot of crossover with North Carolina. I see that all the time. They have a self-proving affidavit, doesn't mention 14 years of age.
That's very, very interesting. That's interesting. Now, I know when we have people that move to other states where we have done their estate planning documents, we will tell them that they really need to have a local lawyer take a look, certainly at the financial power and the medical decision-making document, for the very reason you just stated, that our documents may be perfect and they may actually, say all the right things, but they may not be well recognized by the local jurisdictions that have to deal with those things, especially the hospitals. So it's worth the time to have someone take a look at it. I've never heard about that particular problem with the will before, but I'm going to add that to my list about what people should have lawyers take a look at, because even if your trust is fully funded, you still want to make sure that you have that will as a backup that it's actually going to work. Okay. The last thing I want to touch on, you mentioned that that revocable trusts that are already in place, that you would tell folks a lot of times to keep those in place. But you're a Georgia attorney, so if you have someone who shows up in your office with a Virginia revocable trust, are you able to update that revocable trust since it's based on Virginia law?
I would not. I can restate it, and that is simply a method of really conforming the existing trust to comply with Georgia law. Or we can always get the benefit of your wisdom, Richard, and maybe we don't need to do anything with the trust, and maybe it can stay as a Virginia revocable trust with no consequences.
Well, certainly, I think your approach is exactly what we would expect. We see the same thing for folks coming into Virginia. I can't comment on Nevada law or Oregon law or whatever it might be, but what I can do is I can amend it and restate it and make it under Virginia law, and then I can do your changes for you. So that's good advice, and I think that's an appropriate way to proceed. Well, we're starting to wind down a little bit. We have a little bit of extra time, so let's talk a little bit, though, if you could, and you can provide a little more expansive comments about some final words of advice you might want to share with folks about, the ancillary probate process in Georgia, and things that they might consider doing in advance of in the course of doing their estate planning, things they might do to avoid having to get involved in ancillary probate, whether it's in Georgia or, frankly, any place else.
Sure. So one thing I would like to point out is, as far as I can tell, this is specific to Georgia, but Georgia has a statute called muniments of title, and muniments of title is a way to get around ancillary administration. And the muniments of title statute says when there has been an executor appointed in another state, Virginia, for example, and you file the triple sealed paperwork that you talked about, Richard, from the Virginia court, the Virginia executor has the authority to sign a deed conveying real property in Georgia, and that's called the muniments of title statute.
Interesting.
The problem with that is title insurance. The title, as you might imagine, a lot of the title insurance agencies, because it appears to be a particular Georgia law, are very hesitant to insure title when the property is passed under the muniments of title statute, even though it couldn't be any more black and white that the executor has the power to do that. So if you are trying, and if you can avoid ancillary probate, of course, avoid ancillary probate. If you are trying to convey property through the muniments of title statute, it is imperative that the title insurance company, the real estate closing attorneys know well in advance that you're traveling under that statute to make sure that you can get insurable title, or you might have a disaster at your closing.
Well, that's very interesting, and that's good. That's very, very good advice, because we don't want to get to closing and then all of a sudden find out that there's a problem, and then closing, gets delayed, or because it might take I don't know, two to 4 weeks to get that paperwork processed by the local probate court. So that's very, very good suggestion. Well, Tim, I got to tell you, this has been very, very helpful. What I'm very impressed about with Georgia, both in the overall probate laws down there as well as ancillary probate, is how easy they really try to make it for people to handle this with the detailed forms that basically help you move the process along. So that's a credit to the legal system down. You guys have done a great job to make probate not so foreboding to people who have to take care of that. So great job down there in Georgia.
Yeah, I couldn't agree with you more, Richard. We have a great probate bar down here. The probate court judges are great. The staff is great. If you're not represented by an attorney, you can always pick up the phone and call the particular probate court. Now, they're not allowed to give you legal advice,
of course,
but a lot of times they can give you enough information to get you what you need in order to file. It is almost without exception, the probate courts are customer service oriented. They're looking to get stuff done. They're not looking to find reasons to find faults. They are aware we're talking about somebody who's passed away, and it's not it is a difficult situation, and they're not trying to make it any more difficult.
Well, that's great. Well, Tim, I want to say on behalf of the Probate Nation, I want to thank Tim Curtin from Atlanta, Georgia, for taking the time to educate our viewers on the work that will need to be done in a Georgia ancillary probate administration, and the importance of updating existing estate documents as you relocate to Georgia. Valuable information and a great public service for those viewers who need to undertake a Georgia ancillary probate. So, Tim, thank you very much for coming on the show today.
Thanks, Richard. I appreciate you having me on.
You bet. Without a doubt, probate can be complicated and time-consuming. And this is even truer if you need to probate assets in another state through a process called ancillary probate. Many non-residents of Georgia own second homes in Georgia, especially beach houses. And our show tonight introduces you to the process that will need to be undertaken should you need to probate that Georgia beach house owned by a decedent. While the process seems consumer-friendly, and it is, I would be remiss if I did not emphasize the importance of consulting with a local Georgia attorney about any ancillary probate you may need to initiate. The guidance of an experienced professional will help you avoid unnecessary work and pitfalls for the uninformed, while shortening the time you ride the ancillary probate train in Georgia. This brings us to the conclusion of our show. I hope you find the show helpful should you need to undertake ancillary administration in Georgia. And remember that replays of this show and all shows to date can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.